Recently the Supreme Court has, in two cases, interpreted the 2010 Protection Against Harassment in the Workplace Act. And it has interpreted, in particular, the definition of harassment in the law to include a range of conduct in the workplace that is rooted in gender-based discrimination. And the Supreme Court has clarified in two decisions that it is not only conduct that is of an overtly sexual nature that will be deemed harassment under the law, but also, as I mentioned earlier, conduct that is rooted in gender-based discrimination and is a reflection of sexist attitudes and beliefs. So in doing so, the Supreme Court has significantly expanded the definition of harassment in the law and has also expanded the range of conduct that is prohibited in the workplace. And so I think these are significant judgments. I think one was passed this year, and a previous judgment was also passed in 2021, I believe, which also had this expansive interpretation of harassment. And so I think these are examples of significant cases that will help to promote gender equality in the workplace. So one of those laws requires establishments which employ 70 people or more to provide daycare centers in their facilities. And this law, however, is only applicable to the Islamabad capital area. So it's not applicable all across Pakistan. And the second law, which makes maternity and paternity leave mandatory, is applicable to public and private establishments under the administrative control of the federal. So it's a certain category of employers to which that law will apply. So both of these laws are quite succinct, and one of them mandates daycare establishments for those employers that fall in the within the limits of that law, and the other one provides for paid maternity and paternity leave. And these laws themselves don't provide for any benefits beyond these. Well, I think one thing to note is that the law is not specifying the nature of the facility. It's not specifying any kind of size of the facility. It's not specifying, how many people should be hired specifically to run that facility, to look after the children in that facility. It's possible that the rules, if and when they are made under the law, will specify that further. But right now, in terms of what these daycare facilities are supposed to look like, is quite vague. So there's quite a lot of room for employers to enforce the law whichever way is suitable for them. Another thing to note is that it is applying to relatively large establishments. So it applies to places that have employees that are at least 70 or more. So presumably it's applying to workplaces and establishments that have significant revenue, that have significant turnover, and therefore for them a daycare facility should not be a significant burden. Having said that, if there is an establishment which has a high proportion of women, who are mothers, then obviously significant accommodations will have to be made. Of course, it is going to be an additional burden that is imposed on employers, but keeping in mind that it is a law which has been passed to promote gender equality in the workplace, to encourage more women to join the workplace and then to stay in the workplace, to encourage women retention in the workforce, then it is important to keep in mind that it is a priority of the state to ensure that employers make these accommodations. And so, that additional burden has been deemed to be consistent with the state's human rights obligations and women's rights obligations and their goal to promote gender equality. No, not set forth in the law itself. So this law is also very succinct. It has only 8 sections and it's 3 pages long, and it does not in itself lay forth any monitoring mechanisms or implementation mechanisms. Again, it's possible that rules will be made that specify that further, but currently it's not clear in the law how this is going to be monitored. And another ambiguity in the law is that the penalty that is set forth, which is a criminal penalty, it's imprisonment for a term of up to 6 months, applies to a person. It applies to a person. It doesn't specify that it will apply to an to an establishment or to an employer. Those two categories are defined in the law. However, when we look at the offense and the punishment section, it will apply to a person. So to me, there seems to be an ambiguity also as to who, as to the range of entities that can be held accountable under the law. Currently, to answer your question, currently, as I said, the implementation and the monitoring mechanisms are not clear in the law itself.